Good morning, everybody. Anybody not ready? All right, I'm Pinellas County Sheriff Bob Gualtieri, and we're here this morning, as we put out in the media alert earlier this morning, we're here to discuss the shooting that occurred a week ago, Thursday. I had a meeting last week with the Upper Pinellas Ministerial Alliance and the Upper Pinellas branch of the NAACP. We had a good discussion. We had a good meeting. I thought it was very productive, and decided as a result of that meeting to hold a press conference today jointly with them to let everybody know where the investigation is, the status of the investigation, and to hopefully clear up some things that they conveyed to me were of concern in the community. My relationship with them has been long-standing and have a good dialogue and a good relationship with both organizations. And for some reason, they called about a half hour ago and said that they weren't coming. So you have to ask them why. I'm disappointed they're not here. I continue to want to have a good relationship with them, and I know we'll have that, and work with them so that people have an understanding, not just in this case, but in all cases, about what we do, why we do it, and that dialogue is very important to me. But the fact remains is that here at the last minute, they decided not to come, and I decided that we'll go ahead anyway and convey to you what I was going to convey with them here. So a lot of things have been said since this incident happened on July 19th. A whole bunch of people have offered a whole bunch of different opinions. And I'd suggest to you that the mere fact that so many people have so many different opinions validates that the decision not to arrest Draka at this stage is correct under the law. The facts of this case can lead reasonable people to different determinations, and as I'll discuss more here in a few minutes, the law says don't arrest in this situation and let the state attorney figure it out. So as I begin, I ask everyone to keep in mind that not all the evidence has been made public. We've seen different versions of the video and interviewed many people whose statements have not been considered by those offering their opinions, not seen by the public or by the media. Accurate facts matter, and all the evidence must be fully considered in any case, but especially a case like this, before anyone forms a final opinion. That includes opinions formed based on camera angles without the benefit of witness statements. The camera angle some people are basing their opinion on is high into the east. And remember that Draka was northwest and on the ground. Also, no one offering an opinion on this case about what was done or not done has the right to change or embellish the facts, because changing or embellishing the facts changes the outcome. I tried to be clear in the press conference a week ago Friday, but there remain some serious and important misunderstandings about the investigation and its status that I need to address. So to the extent that I was not clear previously, let me do so now. This is an ongoing investigation by the Pinellas County Sheriff's Office, and it is an open case. We are still actively investigating this matter. We have not turned the case over to the state attorney's office, but we anticipate doing so shortly. You know, this is a very long route on a path, and this is the first stop on that route. So just picture a bus route with a bunch of different stops, and this is the first stop. This is not the final stop. Any decisions that have been made are preliminary decisions at this stage of the case and are based on the facts and based upon the law to be applied at this stage. These decisions, as I said, are not final as to whether Draka should or is going to be charged. The final charging decision will be made by the state attorney, as the law says it should in this situation. I've said from day one that this case will be referred to the state attorney's office. I've never said the investigation is complete or over, and in fact, I've said the contrary. As far as my decision not to arrest Draca, my decision is based on the requirements of Florida's stand your ground law. It is a preliminary decision about arrest and not a final decision about charges. Again, I make decisions about an arrest and the state attorney makes decisions about charges. That's our system. If charges are filed, then a judge decides whether to dismiss the case, and if not, a jury decides guilt, followed by an appellate court deciding if the prior decisions were right or wrong. Again, there are many steps in the process along this route. My decision not to arrest is because Florida law creates a situation where someone is immune from arrest if their conduct is arguably within the parameters of stand your ground. This is not a defense to be merely asserted at trial or after commencement of criminal proceedings. This is an immunity from arrest. So look at the law. The law says that law enforcement, quote, may not arrest. Look at Florida statute 776.032. Now, a lot of people have, again, offered a whole bunch of opinions. They need to do so with the statute in front of them. And look at the case law. So let's do that, because this thing's got twisted around so many different ways. A person who uses or threatens to use force as permitted under the law is justified in such conduct and immune from criminal prosecution. And that section of the statute goes on to define immune from criminal prosecution as including arrest or detaining somebody in custody. So you are immune from arrest and immune from being detained in custody. It goes on to say that a law enforcement agency may use standard procedures for investigating the use or threatened use of force, but the agency may not arrest for using or threatening to use force unless it determines there's probable cause that the force was used, that the force used or threatened was unlawful. To determine that, we have to consider the person's authority to use force, because if someone has authority to use force, then it's not unlawful. And if they have authority to use force, then you don't have probable cause that an offense has been committed. So look at the statute that authorizes people to use force. It says that somebody is justified under 776.012. A person is justified in using or threatening to use deadly force if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or herself. That statute goes on to say that a person who uses or threatens to use force in accordance with the subsection does not have a duty to retreat, has the right to stand his or her ground if the person using or threatening to use the deadly force is not engaged in criminal activity and is in a place where they have a right to be. Draca was not engaged in criminal activity, and he had a legal right to be where he was. So go back to the beginning of the statute. And when the Florida legislature passed the bill that resulted in this statute, look at what they wrote in the preamble of 776.032. It says the legislature finds that it is proper for law-abiding people to protect themselves, their families, and others from intruders and attackers without fear of prosecution. Remember, as defined in there, prosecution includes arrest and being detained. Without fear of prosecution for acting in defense of themselves or others. So look at what the Florida Supreme Court has said about this in a 2010 decision in a case called State versus Dennis. The Supreme Court said that this immunity provision expressly grants defendants a substantive right not to be arrested, detained, charged, or prosecuted as a result of the use of legally justified force. The statute does not merely provide that a defendant cannot be convicted as a result of legally justified force. The Supreme Court went on to say that it doesn't limit its grants of immunity to cases where material facts are disputed or undisputed. Immunity applies even where facts are in dispute, such as this case. The Supreme Court went on to say the grant of immunity from criminal prosecution, again, that includes arrest, must be interpreted in a manner that provides the defendant with more protection from prosecution, including arrest, For a justified use of force than the probable cause determination previously provided for prior to stand your ground. Simply put, a probable cause decision to arrest must be balanced against the immunity from arrest claimed under the justifiable use of force. In sum, the law has taken away law enforcement discretion to arrest unless there is no stand your ground as a matter of law. To arrest, it must be so clear that as a matter of law, stand your ground does not apply in any way to the facts and circumstances that you're presented with. That is not the situation here. The facts are not so clear that this is absolutely outside the boundaries of stand your ground. So in order for me to arrest, it has to be as a matter of law outside the boundaries of stand your ground. If it's not, which this is not, then the law says you may not arrest, and the person is entitled to immunity from arrest and from detention. Remember, you all don't have all of the facts and have not seen all of the evidence because it is an ongoing investigation. I've seen the evidence. And this is unlike any other situation in Florida law. Normally, we evaluate whether there's probable cause that a crime has been committed, and if so, we make an arrest and charge the offense. We don't normally work to evaluate or investigate defenses that someone may raise, but not here, because this is not what the legislature and the courts have said is required in a stand your ground situation. When the legislature created Florida's stand your ground law, it said we don't want people who have arguably acted within stand your ground law to sit in jail while the state attorney's office spends weeks or months considering whether to file formal charges. When a citizen, and in this case a concealed carry permit holder, has claimed that they acted in self-defense, it should be closely considered before having that person sit in jail. So what the legislature said is law enforcement may not arrest, leave that person out, and let the state attorney's office figure it out. And that is simply what we're doing here. The recently created burden that the state has to prove the shooter is not entitled to stand your ground immunity by clear and convincing evidence is relevant at this stage too, because it goes to the person claiming stand your ground's right not to sit in jail while all this is sorted out on an issue where the burden on the state is high. So my decision not to arrest is merely doing what Florida law compels. Don't leave somebody sitting in jail who claims they acted in self-defense while the state attorney figures it out and makes his decision, which could take weeks or months. My decision not to arrest is not condoning or approving Drake's actions. Make no mistake about that. But I have to apply the law as written at this stage of the proceedings. I stand by what I said previously, and that I believe in the adage that just because you can does not mean you should. Does this law create a situation where people reverse the adage and do because they can and not because they should? And does it create a shoot first and ask questions later mentality in some people? Well, I'll leave all that to those opining on the topic. It'll give them something else to talk about tonight. The immunity from arrest is what drives my decision because it eliminates law enforcement's discretion in this case. Absent that immunity from arrest and the recently enhanced burden on the state to show by clear and convincing evidence that Drake is not entitled to this immunity, Drake would be sitting in jail right now and the system would be working to figure it out. The easy thing in some respects would have been for me to arrest Drake and kick it to the state attorney. The easy thing is not the right thing or the legal thing to do based upon the application of law in this case. I've never done anything because it's the easy way or what some might call the politically expedient thing to do, and I'm not going to start doing it today. I believe in the rule of law and that my obligation is to follow its dictates. I don't make the law, and I do not do what people want because of outrage. If you're outraged by the law and don't like the law, then change it. But until then, we follow it as written and interpreted by the courts. Therefore, this case passes to the next stop on the route, and that is the state attorney's office, where they will sit with all the facts, the evidence, and the law, and make a charging determination. In the meantime, as it was the intention of the Florida legislature, Draka is not to sit in jail while that process is occurring. We're very fortunate in this circuit to have an experienced state attorney, and I know he will apply the law accurately and fairly and reach the correct legal decision based on all the facts once he receives the case. And we will continue to do all we can to support the state attorney in the investigative process. So with that, I will take your questions.
Sheriff, local lawmakers have expressed interest in a special session to possibly amend the Stand Your Ground law. Would you take a stand on that?
I'm not going to, that's up to them. The legislature acts, the governor has to decide. That's, again, that's the the legislative branch. They get to make their own decisions. I'm not going to offer an opinion on that.
I understand you to say there's another angle, another camera angle and more video?
No. There's different versions of it. There's slowed down versions and clearer versions and other versions. What I was saying is that be careful not to form an opinion and draw conclusions based upon the angle from which you all, we all, everybody is evaluating this, because people are evaluating it from the camera angle that is high up and to the east. That's not where Draka was sitting. He was sitting northwest and his rear end was on the ground. So the question will become, what did Draka see? What did Draka know? It's not what that camera angle shows. So be careful about that is my point.
Has Mr. Draka talked to investigators and told them exactly why he was at the store? Because he parked and didn't go in the store and then walked over and confronted a mother and a child in a car. What was his reasoning for that?
He goes to that store every day.
Yeah, but he didn't go in.
He was going to.
Yeah, but he went over there.
Right.
Do we have it? We don't have the pleasure of audio of what he exchanged with that mother and child, do we?
No, there is no audio.
There's no audio. So, reason to believe that everybody in the community and a lot of newspapers and broadcasters are saying that the criminal act occurred when McLaughlin came out and pushed, not slammed, but shoved Mr. Draka.
Right.
But we don't know what was said to the wife and child.
No, we know.
That would drive a father to come out and get in between, because she was out of the car already. Am I wrong or right? She was out of the car.
You can watch the video.
No, but I'm just saying, she was out of the car.
She was getting out of the car.
Right, and he was there like this, talking to her.
As McLaughlin was coming out the door and walking down the sidewalk, Brittany was getting out of the car at that point as he was coming down the sidewalk.
But can you shed any light on what was said between Brittany and
again, this is an ongoing investigation. We have witness statements from Brittany Jacobs. We have statements from Draka. We have statements from a whole bunch of people. And I'm not going to get into any more specifics other than what I have already said and said previously. Is that there were no words by all witness accounts, everybody. There were no words exchanged whatsoever between McLaughlin and Draka, none. There also were no threats made by Draka to Brittany Jacobs, and that is Brittany Jacobs.
She said he made threats.
Yes.
What did he say to her?
They were engaged in discussion, a loud discussion, about her parking illegally in the handicap spot. Yeah, and that's what it was all about. And it was all about her parked in the spot and him complaining that she was parked in the spot.
Which he's done numerous times before.
Well,
yeah. That's what the store owner said, and that's what the truck driver said, which he allegedly escalated that. Sheriff, bear with me. That he confronted this truck driver using the N-word, saying, "I will shoot you." Why that truck driver didn't make a report, which would really give you a good modus operandi of how this guy thinks and moves, because this isn't the only convenience store that members in the community says that he does policing.
So what's your question, Reddy? It's a speech.
My question is, have your investigators talked to the truck driver that he confronted a week or two before, allegedly?
I believe so, yes, and again, it's still an ongoing investigation. And, and I'm not going to get into all of that. It gets complicated. What matters, okay, legally in this case, and I said this before, so I'll say it again, but I already said it once. What matters in this case is what happened on that day. Right. Legally, that's what matters. And what matters as far as my determination at this stage is what happened on that day and whether it is clear as a matter of law that he didn't have the right to use the force he used, and there is no way, based upon the facts and the evidence, that it is clear as a matter of law, and because it's not clear as a matter of law, then the law says that he should not be sitting in jail while this is sorted out, and so he sits out, we conduct the investigation, we send it to the state attorney's office. As the Florida legislature has said, people are immune from arrest, immune from detention, unless it's absolutely clear this is what you're not to do. I said in my prepared remarks, and I'll say it again, if it wasn't for the immunity and it wasn't for the heavy burden of, remember, you know, when this thing progresses, and if the state attorney charges, is that all Drake has to do is wave the flag of stand your ground. He has no burden whatsoever. Then the state attorney has a heavy burden of disproving his entitlement to stand your ground. So when you put all that together, is that at this stage of the proceedings, I'm following the law and doing what the legislature has said not to do, and don't have this citizen who claims that he was acting in self-defense sitting in jail while people are figuring it out. And once they figure it out, the state attorney, I know and I'm very confident, will make what is the right decision under the law, and then it will go from there.
One last question, Sheriff. I get the feeling that you're bound by this law and you have to follow it.
Well, of course.
Drake is free, he's at home. What happens when he gets in another argument and shoots somebody else during this time frame? How would you feel?
Well, that's a hypothetical. You know, that's hypothetical that doesn't exist, and I'm not going to answer hypotheticals. And if you
got a guy with a gun that threatens people in parking lots?
No, because there's no history here with him of shooting. And if you don't like it, and you don't like the fact he's not sitting in jail,
it's not what I like. I'm asking you a
go
question.
talk to the legislature.
I talk to them every day. Some of them are not happy about the law, but
well, then check it.
It's just a question to you as a top law enforcement person here. And I know you have wife, family, kids, and everything. It's just a question of how would you feel if, while he's sitting at home, he gets in another confrontation at another parking lot about a handicapped spot?
Then we'll address it and consider it under those circumstances. You know, like I said, he is, under these circumstances, as the legislature has created, immune from arrest. If that immunity from arrest, and this was merely a defense to be asserted in a case, then that's what happens in every other case. Somebody goes out and does something, we investigate it. If the facts and the law meet and there's probable cause to make an arrest and we believe a crime has been committed, then we arrest. Then they have an opportunity to assert defenses once the case begins. We do that all the time. Our job isn't to look at their possible defenses, investigate their possible defenses, but not here. Why? Read it. It says may not arrest. It says immunity from arrest and detention. It says that unless it is absolutely clear, don't do it. My job is to follow the law, and I'm going to follow the law.
Sheriff, have you ever talked to the state attorney's office before making your decision not to arrest, or that's totally something that you and your investigators, or you decide?
To answer the question directly, but I'm not going to get into the conversation at all, is that I had a discussion with a state attorney before the press conference on the 20th.
Do you agree with the law as it stands? The change that happened this year, that the burden of proof is on the prosecution. I know your agency just enforces it. Could you take a stand for us today on the law as it is now? Well,
remember when that was originally proposed to increase the burden and put the burden on the state, because remember, at first it wasn't addressed, and then the Florida Supreme Court said that it was a burden that was on the person claiming it and by a preponderance of the evidence. And the Florida legislature said they don't like that. And what was proposed originally was to change it where the burden would be on the state attorney and proof beyond a reasonable doubt, which is the highest standard that you can have in any criminal proceeding. So, you know, I was involved in that up there in Tallahassee. I was aware of it. It was going on, and that was negotiated to bring it down to a clear and convincing evidence standard. You know, is that I think it's a mixed bag in some respects. I can see the arguments as to why something like that may appropriately be on the state, but I also see reasons why maybe it shouldn't be. So I think it's a mixed bag situation, to be honest with you, because you have so many different situations that can arise under the stand your ground law. But the stand your ground law doesn't differentiate between a situation where it is a use of force against an armed adversary versus a situation where it's a use of deadly force against an unarmed person. So it's a very, very broad, and everything's lumped in all together. And I think that's what makes it oftentimes a mixed bag. Some cases are clearer than others.
Was your decision made with the, for lack of a better word, fear of a potential lawsuit in mind because of the law as it stands now?
Well, you know, that is a consideration. I don't want to ever falsely arrest somebody and subject the taxpayers to liability and having to pay attorney's fees and damages and everything else because of something we do. That's not right either. But is it, you know, out of a fear or concern? No, what I'm trying to do is trying to do the right thing based upon the law and the facts in this case and follow the dictates of the Florida legislature when this law was passed and what the case law is that's interpreting it that says what I should do at this stage. And trying to do the right thing and not have, because that's what they've told us we should do, is not have somebody who's a citizen who's claiming that they acted in conformity with the law and they acted under the stand your ground statute, sitting in jail for weeks or months or however long it is, when it is something that is extremely complicated, that there's all differing views and legal views on. You got lawyers out there saying I got it right, and you got lawyers out there saying I got it wrong. But remember, none of those people also have seen all the evidence. So you got all these opinions floating around out there, and you got a whole bunch of different interpretations of a whole bunch of things, which tells you it's a complicated issue. And I do think the legislature got it right in this respect, is that it is a very complicated issue, and the entity, the person, the state attorney, who ultimately has the burden of proving the case is the one that should make this decision, because it is a legal decision. It's an application of law to facts. It is a legal decision. I think that's absolutely right. I don't always agree with that premise because we have a role, and our job is to investigate and make arrest decisions. But I think that is right in this case, that because it is so complicated and because they ultimately have the burden, the person who is charged with meeting the burden is the person who should make that decision. And so I think that is right.
Sure. Is there any comment on a political article?
Hey, I can't answer one. Go ahead. I'll come back.
Comment on a political article that came out yesterday where some of the lobbyists, NRA lobbyists and Republican lawmakers in Tallahassee are saying that you misapplied the law.
Well, I didn't, and I had a discussion with Mark Caputo yesterday, who wrote that article. It's unfortunate that Mark and I didn't talk before he wrote the article. There's a number of reasons for that, but we didn't talk. I believe, based upon my discussion with him, I don't think the article would have come out the way it did if we had an opportunity to talk. I think he has a better understanding of what I said and what my position is after it. I talked to Marion Hammer yesterday from the NRA and had a discussion with her, and I exchanged voicemail messages with Senator Bradley yesterday. So I didn't get it wrong. I think one of the problems in that political article and what that political article, you know, and remember, political is what? Political, okay, is that the reason why that article was written is because you got some Republicans that are saying one thing about a Republican. The whole thing's driven about Republican politics. That's what the whole thing was. So anyhow, is that let's not put labels on it. I think the problem we're having with that concept is the label of objective, subjective. It is confusing. It's hard legal stuff. I know what the standard is. I'm not wrong about the standard. I'm well aware what the standard is. And as I said in an exchange text with Mark Caputo, who wrote that article yesterday on it, is that what I was trying to do, and probably did maybe too good of a job of it, is to convey to people that it is not purely an objective standard. It is an objective standard, but it has a subjective component to it because it has to be considered through the lens of the person that used force. And so there are components of it that matter what that person knew, when they knew it, how they knew it, and other factors that are in their head. So all that has to come into the objective reasonableness of it. So it all gets put together. So it's not, as I said, it's not purely objective. There is a subjective component, but when you start talking about these labels, I think that's what confuses it. And I was answering questions on the 20th and got into this whole discussion about objective, subjective, and I think it took on a life of its own and went down a path that it probably didn't need to go down. And so when they're asked, and when Marion was asked, and when Senator Bradley was asked, and Senator Baxley was asked, is it objective or subjective? And they say, oh, no, it's objective. They're right, it is objective, but it's objective, but it has to be viewed through the lens of the person under the circumstances of the time, which inherently has some subjective components to it. That's all. So, again, I had a good discussion with all of them, and, there's no difference.
Say that you've seen several different camera angles. I mean, we've obviously only seen.
No, remember that. Be clear, you guys. Listen to what I'm saying. I didn't say that. I said I saw different versions. Okay, Okay, in different speeds and different magnifications. There's only one camera and there's only one angle. Okay, so I never said that. I never said there's different angles. What I said about the angles is, and I'll say it again, be careful about judging this from the angle in which you see it the way I see it, because the way you see it and the way I see it from up here going down is not how Draca saw it, which is down here going up.
But a guy's on the ground, he's on the ground, and so a guy's on the ground, a guy's coming towards him, and then as we've all seen on the camera, it appears that he's backing away. Can we really say, and I know the answer that you gave me on the 20th, but I'm going to ask again, do you really believe that he was in imminent fear for his life on the ground as we see him turning away?
What I'm going to say to that is just leave it at this, is that his claim, based on the facts and the evidence, is not outside the bookends and not outside the boundaries as a matter of law. Based upon that, and based upon his statements, and based upon others' statements, and the evidence we have, and that's my only determination, is whether it is so far outside the bounds that as a matter of law, that defense is not available to him. That's my only determination that I have to make, and that's the determination I made, and that's the determination I stick with, and I know it's the right determination to say, we're not going to arrest. We are going to continue to investigate, and we're going to send it to the state attorney who has the burden and therefore should make the decision, and is the one the law says should make the decision on this, without him sitting in jail for whatever amount of time it takes the state attorney to make his decision. And again, I'm 100% confident. I know the state attorney very well, and he's very experienced, and he's going to make the right decision in this based upon the law and the facts. And that's the way he operates, and I know that that's what he's going to do. He's going to apply the law to the facts and make a decision.
Get this case.
Shortly.
And building on that question.
Hang on, she was next.
Sheriff, is your agency keeping a close eye on Draca? Do you know where he is at the moment?
No.
So he can flee the country for all we know.
Well, there's no evidence of that. Again, we did have some discussion about that with some concern about his local ties. He's lived here for a long time. His wife here, she works locally, and there's no indication of that. So, we did have, that was something, but again, that's not necessarily one of the decisions in here, but it is something that factored in, and there's no indication of that, is that he's still here. He's still around. Somebody asked me over the weekend, you talk about how stuff gets, I got a question from a reporter over the weekend, about whether we had him in some type of protective custody or some safe house. No, okay, it's, no, he's living at home, and he's here, but he's here, and he hasn't gone anywhere.
Are you checking in with him at all? I mean, going back to the concern from the community that he could be a danger.
The investigators have periodic contact with him over different issues, but we're not keeping tabs on him, no.
I guess more importantly, does he still have that gun?
No.
You have a gun?
Yes.
Okay.
Hang on.
There is a provision of the law that the fear has to be reasonable. Yes. Right. Can you give any more specifics on why you came to the conclusion that his fear was reasonable? I'm
not going to get into that. I don't think it's fair. Again, at this investigative stage, I think that you have to look at it all, including video recorded witness statements and other evidence. And I'm not going to get into that because I think the right thing to do at this point is to take all of it and let the state attorney have it and let him make what he believes is the appropriate decision under the circumstances. At some point in time, you all have it and you all can draw your own conclusions and form your own opinions.
And is there anything, I mean, you were very emphatic at the July 20th news conference in your decision not to arrest Draka, and you didn't mention that it was being forwarded to the state attorney until toward the end of the news conference, and I know that was published on YouTube and members of the public watched it, but is there anything you would have done differently in the way that you addressed it initially? Yeah, that was a discussion I had. Unfortunately, they're not here with the NAACP and the North Pinellas Ministerial Alliance, and I'll say to you the same thing I told them as they asked me that same question, is that I would have made it clearer that this was the first stop and it was still an active investigation and that it was going to be referred to the state attorney's office. You know, that press conference, lasted probably about 30 minutes and there were a number of things that were discussed. It did come up and I did say it, as you recognize. But I think I would have made it clear so that the public, and that was one of the reasons of having this today, was based on that discussion with the Ministerial Alliance and the NAACP, that unfortunately it was not clear, and I hope we've done that today. It was not clear to people in the community, and some people were under the erroneous impression that my decision somehow was some final decision or that I was the final decision maker. I'm not. Never said I was, and always said that I was going to refer it to the state attorney's office because that's what the law says you do in this situation. And so, yeah, to answer your question, yes, I would have been more emphatic about that and made it clear so that, and hopefully it would have eliminated some concern that people have that this is a final decision and that somehow nothing else was going to be done with it. And when did you meet with the...
Hang on, Reggie, let her finish. Go ahead.
When did you meet with the NAACP and Ministerial Alliance, and have you talked to them since then before they canceled this morning?
I met with them last week. It was either Wednesday or Thursday, and I've talked to representatives of the organization on the phone yesterday in the morning, but not since. And until they canceled at 9:30, I had no communication with them after yesterday morning or until I called them just before the press conference and expressed displeasure with them not coming. And so I talked to them this morning just before I walked in here.
What did you anticipate?
Hang on, Reggie's next.
No, you were displeased by them not coming. What did they say the reason why?
They said that there was, well, go ask them, about what they, said. I
just want to know what they said.
Yeah, what they said is unfortunately, is that they thought there was some confusion because of that political article yesterday, and that somehow they thought that I was going to call them, and it's absolutely not the case. And I have a good relationship with them, have had and will have and want to continue to have. I do think it's unfortunate that they're not here and that what we discussed last week, because I think it'd be important for you to hear from them. And what I said to them was I was going to make my statements and they can say whatever they wanted. But after I had that discussion with them last week and went through a lot of this that I went through with you, my impression and their statements to me were that they understood now why I did what I did, why I'm doing what I was doing, and that they thought it would be beneficial for the public to have benefit of that private conversation. And so what I conveyed to you here this morning is in essence the conversation I had with the NAACP and with the North Pinellas Ministerial Alliance, and that it would be beneficial for everybody to hear that, to know, again, the status, the stage, and where this is going.
What's taking so long to send this case to the state attorney's office? What are you guys working on right now before it gets sent?
Just putting it together. There's videotapes that have to be, and audio tapes that have to be transcribed. There's still witness statements, witnesses that are to be interviewed. They're just going through a normal investigative process. This is, it takes time.
You said soon, though, I mean, realistically, days, weeks, more than a month?
No. I would anticipate that it will go to the state attorney's office this week. Anybody else?
Can you just give the statute number again, please, Sheriff?
For which one?
The standard ground.
Yeah, the stand your ground, let me make sure, because you got different provisions of it here. So the immunity from arrest is 776.032, and the stand your ground yourself, the section that's applicable here is 776.012. Those are the two most applicable. It's all in Chapter 776, but those are the two most applicable sections. Again, 776.032 and 776.012.
And one more thing, just something I've heard a lot from readers and out in the community is the fact that Mr. Draca initially approached Brittany Jacobs. And I know you addressed this a little bit at the July 20th news conference, but can you explain kind of in the law, if it provides any guidance on, how to determine who the initial aggressor is? Yeah, okay, but it doesn't apply here. And that's, a question that people have asked me is it says under 776.041, it says use or threatened use of force by an aggressor, okay? It says the justification described in the preceding sections is not available to a person who's attempting to commit or is committing a forcible felony. So if Draco was engaged in a forcible felony, then he couldn't avail himself of this. He also couldn't avail himself of it if he wasn't legally where he was and the other provisions that disqualify you from availing yourself of the law. So there's a part 2.
Yeah, I'm reading it. Okay. I'm going there. Okay. So it says that part 2, or you're not available to the person who initially provokes the use or threatened use of force against himself, unless, okay, because then there's another unless. So they keep going down the path. I mean, this is the way statutes are written, is you got a premise, and then you got exceptions, and then they keep building on the exceptions. So take the first one, is it says that it's not available to somebody who provokes the use or threatened use of force against himself or others. And again, I'm limited to what I've already said, not going any further. But when Drake is there talking to Jacobs, there is no threat. There is merely a discussion about why she's parked there in the handicapped spot. Neither one of them are engaged in any threats. There's no provoking of anything. And when McLaughlin is leaving the store and walking down the sidewalk, there are no words exchanged between the two of them. There's no provoking there at all. There's no evidence of any provoking. But if there was, then you got to read the statute further, and it goes on to say, unless such force or threat of force is so great that the person reasonably believes that he or she is in imminent danger of death or great bodily harm and that they've exhausted every reasonable means to escape. So it takes you back to the same place. So that is not helpful to a resolution of this at this stage. A lot of it doesn't apply, clearly doesn't apply, to the extent that any of it arguably applies to this use of force by an aggressor is that it's circular and brings you back to the original analysis.
But sorry, I'm just a little confused by your last point. There is in that last unless the obligation, the duty to retreat, right? That you have to try within every means. No, it says that the justification described is not available to a person who provokes, unless they provoked, and then if they provoked, that the force is so great that they reasonably believe that they are in imminent danger of great bodily harm, and they've exhausted every other means of escape. So again, it's all complicated. It all builds on it. So in order for that to apply, they have to have been a provoker. If they were a provoker, then there's still a way for them to do it if they do some other things.
He seems, I have to say, Mr. Draca seems to possibly have provoked. You're telling me there was no other way for him to escape. He couldn't crawl backwards.
He didn't provoke the attack. The question here is did he provoke? Did he provoke Marquise McLaughlin from leaving that store, trotting down there, and forcefully pushing? Did he provoke that? That's the question. It's not a question of whether he stuck his nose where it didn't belong. I said that before. He stuck his nose where it didn't belong.
Who, McLaughlin or Draco?
Draco stuck his nose where it didn't belong by inquiring of her about where she parked, there. He had no business doing that. And if he hadn't done that, and if McLaughlin hadn't come down and shoved him as forcefully as he did, we wouldn't be standing here having this discussion. So that's what it comes down to, Reggie, is that Draco stuck his nose where it didn't belong. He engaged in a verbal discussion with Brittany about this whole parking thing. I'm not going to get into, you'll see it eventually, what Brittany says her responses were and what others say her responses are, and she was responding to him. And as a result of that, Marquise comes out of the store, and as opposed to saying, hey, knock it off, no, he, without saying anything, and you can characterize it however you perceive it. I'll perceive it as that he was walking at a pretty good pace, okay, and he was doing this with his shorts, and he was getting ready to do something as he walked down there, and he lit the guy up. And so that's why we're here. And then it becomes, at that point, that's what becomes the core question in this thing, is that when that happened with that amount of force, based upon the lens in which Draco viewed it, is that objectively reasonable for him to do what he did within the short time period he did it? And that's why everybody's all over the board with this thing, because it is not clear. And that's what the crux of it comes down to. That's what the crux of this thing is all about. Yeah, well, I don't know about milliseconds, but it's seconds. I mean, and I said this before, so I'll say it again, is that the whole thing is about 4 seconds, and it's probably less during some important parts of the video, less than 4 seconds. It's a 4 count, less. So it is a very, very short amount of time, and that adds to the analysis here. And as I said before, you change the facts of this, you change the outcome. If there were certain things said, that could change the outcome. If the force of the push was different, that changes the outcome. If the time period in which Draco shot is different, that changes the outcome.
How many seconds was that when he was on the ground and shot?
It was a few.
2 or 3?
Yeah, somewhere in there. Yep, right in that range.
Does he have any, how should I say this, my fellow law enforcement folks in the room? Does he have any tactical training? Because he just came up. Like,
he said no.
He said gun range or something.
Yeah, he said no.
None?
Yeah.
Let's go to the range.
No, he said no to that too.
No.
Sheriff, you said that it's your duty to enforce the laws that the legislature has made. By the same token, are you free to criticize or analyze what the legislature has done in terms of what your opinion is on its public safety and your job to enforce the law with our stand your ground legislation?
Well, I guess the answer is yes. Your question is, am I free to do that? Yeah, so your question is,
what do you think of that?
Well, I support the concept of the stand your ground law. I think that there's room for discussion about some changes to it. I think there's room to tweak it, to tighten it up in some areas. But the concept itself, I support and strongly support, because I don't think that in a situation where, and I'll just say it this way, where you are clearly being threatened, that you should have an obligation under the law to retreat before you defend yourself. And before stand your ground, that was the obligation, unless the Castle Doctrine applied. So if you're in the mall and you're walking to your car at 9 o'clock at night and somebody accosts you, yeah, I think you should have the right to defend yourself. So I support the concept of stand your ground. I think people should have a right to defend themselves. I absolutely support the right of people to carry concealed with a permit. We can't be everywhere all the time. Law enforcement cannot protect everybody every minute of the day in every place, and that's a given. So people should have the right to protect themselves, and I support concealed carry permit holders and the right of people to do that and to protect themselves and their families or anybody else. And I believe that they should do that in a reasonable way.
But they should have the duty to retreat.
What's that?
But they should have a duty to retreat.
No. Listen, what I'm saying is that I don't think you should have a duty to retreat. Please don't report and misreport that, because that'll take on a life of its own and it'll blow up all over the news tonight. I did not say that. You know, what I said is that I do not think that people should have a duty to retreat when they are faced with a circumstance where they are in peril. So I support the concept of stand your ground. But do I think that there is room for some discussion about tweaking it? Yeah, I think there's some room for discussion about it. Now, I'm not going to give you specifics of that because this isn't the time or the place to do it. And at the right time or the place, I'm happy to offer some thoughts on it, on some areas where I think there could be legitimate discussion about tweaking it so that it is less ambiguous, it's clearer, and could be applied a little bit more easily than what we're having to go through here.
Why not talk about it now? I mean, it's dominated the conversation.
Well, because I haven't had really a chance. I need to really lay out the thoughts and crystallize the thoughts on it, and I'm not willing to just give you off the top of my head thoughts. And in the last couple of days, I've been busy with a lot of things, and I haven't really been able to sit down and lay them out. And so I'm not going to just lay them out casually until I've had a chance to really think them through and do that. But I've got some ideas, but I'm not going to get into it here.
This has taken obviously a racial undertone in this whole case. What's your comment to that?
There's no evidence of it. You know, people are making it into one. So where is it? I mean, where's the evidence of it? I don't see any evidence of it. You know, I mean, yeah, you're right. There are some people that immediately went to the race card on it. I don't see any evidence of it. There's no statements made. There's no indication of it. There's no, you know, where? Are you talking about Drake's part? Are you talking about my part? Or what are you talking about?
Well, Drake, I guess, for Drake, I guess, like as everyone else was saying, was that the previous people that he had approached were African Americans. And then as far as...
Not all.
Okay, well, that's good to know. We're just asking, but as far as like the people in the community who are saying like the sheriff is not arresting Drake because he's white. You know, so can you just respond to those accusations?
So it's absolutely not true. It has no bearing whatsoever about anybody's race, national origin, gender, etc. Not arresting Drake because he's white is nonsense. There was a stand your ground case last year, 2017. It was a white guy, white female. Guess what? We arrested him. Guess what? The state attorney said, we're going to dismiss the charge because stand your ground applied. 2012, we arrested a guy. He was white. State attorney said, stand your ground, and he dismissed the case. So that's a bunch of nonsense. People making something there that is not and jumping to conclusions that are irresponsible, because that's what gets people fired up. And that is so wrong and so irresponsible, and there's no factual basis for that whatsoever.
I mean, there's people coming to town playing, you know, saying that this is the issue, so that's why I wanted to...
Well, they're opportunists. That's self-serving. They're doing it because it fits their mantra, it fits their narrative, and it's all a false narrative. Of course they want to do that because they don't have a pulpit to preach from or an audience to speak to unless they can spew that kind of stuff. Where's the proof? Where's the evidence? It's all conclusory. It's just wrong and it's irresponsible of those people to do that because there's no proof of it. It's real easy to throw that stuff around. Back it up. Where? Doesn't exist. You know, those are just easy barbs to throw that again are false, irresponsible, and frankly, they should be held accountable for saying that kind of stuff because it's just not true. All right, thanks everybody.